what we do here at Foley Griffin on misdemeanor forfeiture cases is one of the services we provide is not only to represent the persons on the criminal end of the misdemeanor DWI, but we also look to help and get involved in the civil aspect of the misdemeanor DWI, being the car forfeiture. So there's a couple ways to do it. The first thing I like to do is call the attorney's office that handles these matters for the county, and that's a gentleman by the name of Andrew Campanelli. Mr. Campanelli and I have a nice relationship. We've done a lot of these cases together, on opposing sides. And the first thing I try to do is see if the county is willing to settle the matter. What I mean by that is, if my client is to do X, Y, and Z, would you be willing to return the car to my client under the conditions that we can agree on? That may be a financial condition, that may be a condition that involves an ignition interlock system, it may be both. The second, if the county's not willing to do that, we are entitled to what we call a retention hearing. That's a hearing that the county holds before a judge in Supreme Court, and the judge will decide whether or not the county has the right to retain the car during the course of the criminal case. I've done dozens and dozens of retention hearings where the county has to be held to a certain level of standard of proof in order to retain that car, and we've litigated those as well. And finally, what's nice about us here at Foley Griffin is that we will also handle the criminal case as well. So the criminal case has so much to do with how ultimately the retention hearing and the retention of the car goes. You have one lawyer doing both. So worst case scenario, the car stays in the custody of the county until the criminal case is resolved, and then at that point I've had a lot of success in resolving the retention aspect of the case as well. So that's how we try to help in terms of the civil side of things.